My name is Devin Miller. Do a few different things. Primarily, I run my own law firm practice and have a couple additional attorneys and other staff. It's called Miller IP Law. So we focus on helping startups and small businesses with patents and trademarks. In parallel to that, run a product development firm called Mountain Green Engineering that kind of on the flip side helps startups and small businesses develop products and bring them to market. So kind of two heads of the same coin, but just a couple different companies. And then in addition to that, or on the side, I'm part of a couple different startups, founded or co-founded a couple different startups that I actively participate in those too. So a bit of a mismatch of stuff, but the primary focus or a lot of my time is spent is on the law firm side with the helping clients with patents and trademarks.
All right. So what I'm interested in going through with you, the intent of it is why people need a lawyer early on, why they should seek legal counsel. But I'm going to go down this path with you, and I hope you can help me.
Sure.
Explore it. So what is protectable and what isn't, and how can a lawyer help you understand that in more detail?
Yeah, so maybe the easiest way to think about it is there's kind of three different categories of for different types of protection. So if you look at patents, that's going to be invention. So something that has a functionality, a use that you can do something with, right? So if you think of a product or something tangible, that's going to typically fall under patents. Trademarks are going to be more on your brand stuff. You're going to try and protect a brand such as what your name is, a catchphrase. So you think of Nike and Just Do It, those type of things, or a logo, Starbucks logo that goes on all of their coffee cups. All of those type of things are going to fall under brands. And so you're going to use trademarks in order to protect a brand. Last one is going to be copyrights, and that's going to be more of your creative. So videos or a book or, text or images or photographs, those type of things where it's more of a creative work. So those are going to be what fall under copyright. So those are kind of your three main categories of what you can protect and then what you use to protect those different types of things. I can certainly dive into a bit more detail, but
we're definitely going to.
Okay.
All right. So what I'm interested in is, right, as entrepreneurs, they start building a business, there's two pitfalls, right? One is thinking you can protect everything and then realizing that it's not protectable or was not protected, right? You think you had copyright on a thing and you don't. And then there's the other spectrum where you're not protecting the things you don't know you can protect. So you're actually exposing your business by not protecting them early enough, missing a patent filing deadline, for example. I know is a big one that you'd probably like to cover for us. But it's those two sides of the coin that I'm interested in understanding for our audience and having you share a little more about them. Pick any area you like and go through.
All right. Well, I'll go with the easier area first, but the one that, as far as, sometimes whether things that you should protect that you might not know. And the one that probably, so I would say that typically falls under more patents or trademarks, is sometimes that people go too long or they don't know what they should protect. So on patents, to your point, so that one, you can protect it. So the general time that you can start protecting an invention is what's called conceptual reduction to practice, which means basically if you can describe it in enough detail to someone that's in the same industry that they would understand how it works and be able to reproduce it. From that point forward, anytime you reach that level of development, you can start to protect it. And then the question comes is, okay, now that's where my starting point, when is my drop deadline for having to protect it, right? And that kind of falls into two camps. So one is anytime you introduce anything into the public, so you go and offer it for sale, or you go do a presentation or a conference on it, or you start to go out and pitch it to a lot of investors, a lot of those things start to trigger what's a 1-year deadline. So from the first time you put it out in the public, you have 1 year to file on that patent. If you don't, it basically becomes public domain, which means anybody can use it, anybody can reproduce it, and you lose your rights to it. So that's a lot of times what people don't realize is you're a startup or a small business, you're excited, you want to get something out in the market, you're starting developing, you say, okay, our focus right now is let's get this out, let's get some sales, let's make sure we get a success. All valid points, but the problem is then you wait too long, you've been out selling it for a year or two, then you come into a patent attorney and say, okay, now we finally have some money, we have some time, we have breathing room, let's get that, let's get this protected. And then the attorney's saying, well, we can't protect that. Or you have to start to strategize back and say, okay, what has been less than a year? What are some of the newer features? And this creates a lot more of an issue. The other thing that when you're thinking of as far as kind of a deadline is, so the US, along with most of the world, is what's called the first to file system. Basically means that whoever files on the idea first has a presumption of inventing it, with a few caveats. If you can prove that somebody's, did corporate espionage, stole your idea or something, that there's a couple caveats, but for 99% of the cases, whoever files on it first gets the rights to the invention. So a lot of times the other thing is you wait too long. If it's a crowded field and a lot of people are developing it or do something in there, then somebody else files first and you lose your rights, even though you think, you may have thought of it first. So those are kind of go ahead.
I want to dig just a tiny bit deeper there. So, because I don't want someone to get the impression that you have a year to file a patent, right? Mm-hmm. But in that year, you're covered. It's actually the other way around. In that year, if someone goes file that patent, you're going to have hell to pay to try and prove that it's actually your invention, not someone else's.
Yep, no, exactly. So the one thing is whoever files first, you don't have protection that year. Whoever files first gets the rights to the invention. The other one is if you wait longer than a year, it doesn't matter who files first. That's out in the public domain and nobody can secure the rights to it. So you are right that you're not covered during that year. But if you ever go beyond that year, regardless of whether somebody else filed on it or not, you're also stopped. Yep, I think that's a good point.
Okay. Now, since we're on patents, I'd like to continue on that subject.
Sure.
What type of things can be patented that people normally don't realize should be in terms of protecting your business, right? We take for granted, a new formula, something mechanical. We invented a better mousetrap. You need to get that patented. But what, especially in this new day and age, is patentable and normally people don't know?
Sure. If you were to take the definition from the Supreme Court, anything under the sun is patentable. And then they give a few exceptions, which is you can't patent a perpetual motion machine. That one's one that they've just stricken from. They've got way too many people that tried to submit applications. They just said that one is not patentable. Cure for cancer, they said that one isn't patentable. Now, if you do cure cancer, I'm sure that they'll make an exception. But again, they almost had that. Aside from that, almost everything is going to be patentable as long as it meets about 3 criteria. One is that it has to have a functionality. It has to do something. For example, you can't patent a book. You can't patent a video. You can't patent a logo. Those are what I mentioned, copyrights or trademarks. So it has to have a functionality to it, and you have to be able to, it has to do something. If you meet that criteria, you can do something that's mechanical. You can do something that's software. You can do something that's electrical. I've done everything. Give you a few examples to kind of give you a gambit of what their different ones I've worked on. So I've worked on different inventors have a boat anchor. I've worked on ones that are doing real estate apps and how you can better do that. I've worked on like Intel and Amazon with some of their consumer-facing products. Software, you can do that. And so it's a pretty good spread across what you can, and almost as long as it has functionality to it, it'll meet that first criteria. The other 2 criteria is okay, let's say it meets that bare minimum as something is patentable. Then you have to see whether or not somebody else has already patented it. So when you file a patent application, they go through and examine it and look at kind of 2 standards, which are novelty and obviousness. So novelty is basically somebody else already invented this, and if so, you can't patent it because it's already been invented. The other one is obviousness is, well, okay, not one person has invented this, but 2 or more people. If you're to take 2 or more things that are already out there in the public that people have already done, it would have been obvious you could have combined those together. You're really not adding anything new. You're just taking 2 things out there that are already known, putting them together in an obvious way, and really not adding anything new. So if nobody else has invented it and what you've done isn't an obvious variation of what's out there, there's a pretty good gambit of almost everything is patentable.
Now, what about business processes? Where would those fall for certain companies that might want to franchise, for example? How do they protect that intellectual property?
Business methods are difficult. It used to be easier. So take a few business methods. If you'd have gone about 10 years back, those were regularly filed on. They had a whole lot of patents that got allowed that shouldn't have got through. The Supreme Court stepped in and said, business methods need to be well ramped back. You can't just stop everybody from a method, because a lot of people are doing this for a long way, but business methods are hard to show. If we've just been doing a way of doing business for a long time, it may not have been documented, it may not have been well written down or established, but a lot of people are doing that. And now people are trying to come in and patent that and stop businesses that have already been doing that for a long time. So they ramped that back quite a bit. They are still allowed, but they are much more difficult to get through, and they have to be much more stringent criteria of not just simply how I do business, but more specific as to, let's say, for instance, if I'm a software company, or if I have software integrated, and now I'm going to use a way that I'm going to capture client information, do analytics on it, do a determination, how I'm going to do chat bots, those type of things, you can still do that. But a pure business method of just, hey, this is something that you can do in your head, something that you can do on a piece of pen or paper, or something that everybody's doing for a long time, have been significantly ramped back. So you still can, but that is one area that's more difficult. Software used to be more that way. Software used to be a bit more difficult. There's about a 4 or 5 year period where they kind of ramped things back. It started to broaden back out. A lot of people are still able to get software patents, and I do that for clients a lot. But there is kind of sometimes pendulums that swing back and forth, and sometimes it's wide open and easy to get, and other times it kind of swings the other way and it gets more difficult. So different areas sometimes swing different areas as far as how hard it is to get a patent in that area.
Okay, along the same lines, what about a training document, internal training documents, right? You have an employee starts working with you, you've created a training document for how to handle the kitchen, how to handle the food, and so on. Few years pass, this other company starts to grow that your employee left to build. And you find out through the grapevine, right, that pretty much your training manual and his training manual are pretty much identical. You're cooking different food, doesn't even matter, right? But is there any protection there?
That would fall more under copyright. So you can't protect that via patent because it doesn't really have functionality. It's not a product or an invention, but it does fall under copyrights with a couple caveats. So if copyrights are good at protecting something as far as how it's actually written. So let's say they went and took your training manual, they copied it verbatim, word for word, and you were the first one to come up with that, right? So that is the one criteria. You couldn't have copied somebody else's training manual and then try to go in and tell somebody else they can't do the same thing. But if you put in a lot of time and effort, you came up with a great training manual that, is much more succinct or works better or whatever the case may be. Employee comes in, copies that verbatim, and then goes and uses it. Then they're violating your copyright. So the nice thing about copyrights is your rights are established as soon as you create them. So as soon as you make the document, you take the photo, you write the book, whatever the case may be, you have innate copyrights, where that's not quite the same for trademarks and patents. Copyrights are much more the same. The one thing is if you do copyright registration, it just helps you to define that date so that you can say, hey, I filed this copyright registration. As of this date, I can show that I was the one that came up with it. So that's a lot of times when you get into copyrights, why you register them. But if you were to take that, somebody or copiers, they were to just start using it, doesn't matter how they use it, they violating copyrights. With the exception of, let's say you had a employee thought, hey, this training manual is great. I'm going to take the same ideas or concept and I'm going to put it in my own words. I'm not going to copy it verbatim. I will write it how I think makes sense in my own words, my own flow. And even though the core of the idea is the same, the words are different, the manual is different, they're within their rights to do that. So copyrights are more narrow in the sense you can't just protect the concept or the idea. It is the actual works. But if somebody were to copy it, then you would have copyright rights to go and enforce.
Okay. Since we're on the same subject, let's cover bloggers for a moment as well, podcasters, videocasters. It is
Sure.
my understanding, and I sit to be corrected since I'm not standing, that when you and I create a piece of content together,
Mm-hmm.
that we both have ownership of it unless otherwise stated.
Correct. Yep.
Is that accurate?
Uh-huh.
All
Yeah.
right.
So if there was no duty to assign or we didn't have any other agreements, this podcast, we would both have rights to it because I'm participating in creating it. You're participating in creating it. And so we would both have rights to use it or to share it or do whatever we want, unless there was other agreements that are already in place. Yep.
Now, on that note, I would probably not do this, but just for the sake of fun, right? Since we both own the copyright, if someone decides to redistribute us for fun, right, or for profit, do you and I have to agree that our copyrights have been infringed? And how do we give rights to someone else? And the reason I ask is during COVID-19, there's a lot of content being created.
Sure.
And there's also a lot of people in this industry, right, that we kind of follow each other. So I thought it would be interesting.
I'll give you so one caveat. If you ever ask an attorney to give you a direct answer, they'll almost always say it depends. So there's always an it depends answer. I'll give you the general answer with the caveat. There are always circumstances that make it dependent. But generally, we both have rights to the copyright, so we can both do it as we will. So let's say you wanted to go and enforce it against someone. I didn't give you my permission. You could still go and enforce it. However, the caveat would be is they could go, let's say you went and enforced it against person A. That person A could come to me and say, hey, will you give me the rights to your copyright so that I can do that? And if I granted them their rights, then you're not able to go and enforce it. So we both could go and enforce it, but because we both have equal rights to it, unless we have something else lined out, then either of us could do whatever we want. That we could grant anybody we wanted permission to it. And so that would be the thing. So you don't have to have my permission to enforce it. But if I was on the other side, well, why don't I just go to the other person, get their rights to it, and then it kind of defeats it. So the way you can do that is, but let's give a bit of a different scenario. Let's say you are the only owner. So today I fill out an agreement, I assign over all my rights to that, and you're the only owner of the rights to the video or the podcast or whatever it would be. Then the way you can go about it and assign, you can either do a licensing agreement to where you say, hey, I've got this great podcast or this great song or this great book or this great movie. I'll license it to other people and they pay me a fee. So then you can do it via licensing, or you can just simply assign it over saying somebody wants to buy the rights to this song or this video or this podcast. Then you just do an assignment agreement, assign over those rights, and then they become the new owner. So you can do those type of things if you're wanting to assign things over or somebody else were to take over ownership.
Pretty cool. All right. So on to more. If someone opens a business, let's go a bit towards trademark here for a moment. What's protectable? What isn't? What's the major pitfalls that people fall into thinking that this is mine and then someone else can open something like it?
So yeah, I think there was 4 or 5 questions in there. So I'll try to answer as many as I can. I'll start with what is the pitfall, because I think that sets up some of the other questions. So a pitfall that oftentimes businesses fall into is they come up with a name or they come up with a brand, and then they just go out and just start to use it, but they never file it as a trademark. So they never go and register it. Well, you can have some inherent rights with trademarks, but they're fairly limited. So you can rely on what's called state law or common law, that if you start to use your trademark in a defined geographic location. So let's say today I'm in Utah and I started to use my brand in Salt Lake City. Well, then I do have inherent rights as soon as I start to use them. But now let's say that somebody else came and wanted or started using the same mark, they go register it as a federal trademark, then they have the rights to all the rest of the country. So I can continue to use it because I was the first one to use it in my geographic location in Salt Lake City, but I can't expand out anywhere. I can't go anywhere else and I can't expand my reach. So a lot of times the pitfalls is that companies will come up with a trademark, they'll start to use it, they never register it. Somebody else comes along later, registers it, and then they have this conflict. Well, hey, I've been using this for 10 years or 15 years or whatever period of time. You say, yeah, and you can continue to use it where you already are, but you've lost the rights to expand into new locations or new areas. A lot of times the big companies aren't even aware of it. They go to expand into an area and somebody's been using that. And I know when there's a local example of in Utah, a restaurant that's called Dairy King instead of Dairy Queen. They were using it first in that area, so they continue. They only have one restaurant, one location. They get to continue to use it, even though it sounds very similar to Dairy Queen. So there's a lot of examples if you were to pick through it. But yeah, that's always an issue that both sides do. The one that's huge and expanding thinks they have a guy that's been using it forever, and then they have to either work out an agreement or let the little guy continue, or the little guy starts to grow, wants to expand, and then only comes to find out that somebody else has already registered the trademark, and they run into that issue.
Here's a fun one. I'm going to stick on a point that you made. I just can't let it go. So Dairy King, Dairy Queen.
Mm-hmm.
Sounds like.
Mm-hmm.
Elaborate on that for me in terms of trademark. So you get a lot of knockoffs, right? So on Goggle instead of Google as an example, but how broad is that trademark protection when you protect? If you've got a good lawyer, right? Let's go with you've got a really good lawyer that can protect you.
Right, such as myself, right? If you had a good lawyer like me,
right? So
yeah.
How broad is that?
Yeah, so the standard that they typically will look at is to whether or not two marks can coexist is what's called likelihood of confusion. So basically, if my mark and your mark, or the two that we're competing here with, are going to cause customers to not know who is selling what. So let's say you had Google and Goggle, or whatever your Goggle or Google or whatever your two examples were. Everybody thought it was the same company, or they didn't know who was offering what, and it was causing that confusion in the marketplace. Then you would have the potential for a copy or trademark infringement. So that's usually the standard, and that's the same standard when you're applying for a trademark. So same standard. If I wanted to go and trademark a word today, they're going to go out and search and see whether they think they're the trademark office, if there's anybody that's going to create a likelihood of confusion. So that's kind of one thing is that you'll look at is, hey, if I'm causing confusion in the marketplace, if customers are unsure who's selling what good or who's offering what service, and they don't know, they're getting confused, then you have that issue of a trademark issue. The one other thing you have to think about is trademarks are always specified into different classes of goods or services. So let's say, as a crazy example, and I don't say go do this, but let's say you wanted to go and start Apple trucks, and make your own automobile and trucks. Well, theoretically, Apple right now has their trademarks, but they're for consumer goods, for phones and laptops and electronics, and they haven't entered into the truck industry, and nobody would think that if you had Apple trucks, that was the same Apple. And so you can have the same or similar marks coexist for different types of goods or services, as long as they're different enough that they don't create that likelihood of confusion. So that's why you'll sometimes see in one industry, in a restaurant industry, they'll have the same name as a consumer good or something else, but it's because they're so different, have different customers, have different markets, that they can coexist because they aren't creating that likelihood of confusion. So kind of the two things are, how similar are the marks? Are they creating a likelihood of confusion? And what are the types of goods or services they're offering, and how similar are they?
Very interesting. All right. Anything else you think that maybe I didn't touch on that people should really know when they're thinking about, should I invest in legal counsel or not? After that, we'll go into how you've packaged your services, because I think evaluating the risk with the cost is pretty important, and we'll go there. But
I could go on for hours. I'm trying to think of, if I was a startup or small business or someone trying to figure out what I need, I need to know? Generally, there are firms, and it almost kind of bleeds over the next conversation, but I'll leave it a little bit out, is that we'll sit down and do a strategy session. So I would say generally it's the best advice I could give is go out and find an attorney, and I do it, and I know others do it, so I'm not only unique in that way. They'll sit down and have a free consultation or a free strategy session, and they'll say, here are the things to consider, or the things that you should be thinking about, or that you may want to, and have those conversations early. Even if a lot of times I'll tell people, hey, today is not the time to start. I wouldn't start this today. I would wait 6 months or a year, go out and spend your money in other things to develop your product, and then come back and do it at that time. But you're always better to know earlier than later. And the problem that most of them, or most businesses, look at is they don't do it till later, because legal stuff and patents and trademarks and copyrights aren't the fun things. The fun thing is creating the new business, going out and selling it, seeding the sales, growing the business. And so you always, oftentimes it's kind of an afterthought, whereas if you at least plan for it or have a plan into when you're going to address these on the front end, you can avoid most of the issues.
Okay, so predominantly get specific advice, which if you're smart about it, you can get most of it for free, with regards to whether you can or cannot protect certain things. Beyond that, you're going to need to pay to get them protected, to get
Exactly.
someone's help. But don't be scared to, at least, even if you're kind of cost conscious, cash flow issues, whatever, at least have a chat with a lawyer, reach out, so that you can actually look at your business and protect what you're meant to protect, and as well know what maybe you cannot protect, and just accept
So,
that.
and not just, it's all part of your business plan, right? So, and this is even if you're a startup and you're going to go for venture capital or angel, they're going to want you to at least have a plan, even if you haven't done patents yet or trademarks. At least having thought through it or having a plan as to how you're going to address that gives you a significant higher level of credibility. So there's multiple reasons to just have a business plan as to when you're going to address them. But yep, I think that's a good summary.
All right, now I saw you've got an interesting model going on your website in terms of how you package things, right?
Mhm.
And I'm going to ask you a question that I know I'm going to get a biased answer, and I'm
Sure.
okay with that, because I'm asking other lawyers for their biased answer on this subject. And
Sure.
that's, why did you structure it the way you did? And I'd like you to walk through a little about the way you structured it, and why
Sure.
you think it's better for your customers and makes it easy for startups.
Sure. So I founded my firm about 18 months ago. Before that, I'd worked for some of the top law firms in the country, highly ranked, highly reputable, and they do a great job. So I think they provide a lot of good services. But when I stepped back and said, one is, what do I want to focus my firm on? What kind of clients do I want to help, and what do I want to do? My love and passion is for startups and small businesses. One is I've co-founded and done those, and so I've been on the other side and know idea of the budgets, what the competing interests are, how you're trying to make payroll, along with cover your illegal expenses, along with bringing a product to market, along with your marketing. All of those things kind of stack up. And so when I started to step back and say, okay, if I were to, when I found my firm, when I was starting, is what do I want to focus on? It's the idea of how do I help more specifically startups and small businesses. Have other businesses that are still big businesses I love to help, but I wanted to focus on startups and small businesses. So I said, what are some of the pain points, or what are some of the difficulties that they often find? And one is the billable hour. And so that one is, you go to an attorney, and from the time you sit down, the clock starts ticking, right? So yeah, you feel like every time you call with a question or shoot them an email, you're going to get billed an hour, so to speak. And a lot of times attorneys do that. So one of the things we did in a few different ones was to do flat fees. And so we do flat fees for patents, for if you want to prepare and file a patent application or a trademark application or copyright, that how much it's going to cost you to prepare and file that. So it's not a kind of a feel like it's never ending check to where you're always wondering how much this is going to cost me. On the front end, before you get going, this is how much a patent application will cost me. So that was one of the things that it made it a lot easier, particularly for startups and small businesses that are working on small budgets or confined budgets or their competing interests, that they know how much things are going to cost them. So that's kind of one of the things we did. The other thing is kind of what I alluded to a bit earlier, is we do free consultations, which are the biggest thing that hinders startups and small businesses from going into attorney. Is one, that they think that they don't know what they think that they're going to get charged a whole bunch to sit down with an attorney. They don't have the money, and so they don't want to sit down. They'll figure, I'll wait until I have the money, and it scares a lot of them off. So we figured, let's remove that barrier. We'll sit down. We'll give you the consultation for free, strategize with you, and tell you what makes sense. And to your point, it's a biased answer, but I do always, where I have been on the other side, done startups, small businesses, continue to be involved with them. I try and say, now what what would I want to know if I were on the other side? If I were on the putting on the hat of startup or small business, what would I need to know or want to know? And then I work my way backwards with them on, now what can we do for you? And so I try and give that honest answer as best I can. I'm sure it's always biased because it's hard not to be, but it is trying to infuse not just that, what can you do legally, but what makes sense for you business wise. One third thing, and then I'll kind of take a break for a second and see if you have any other questions, is the other thing we do is the biggest thing, frustration across the industry is that attorneys, and it's not just patent attorneys, it's almost all attorneys, are terrible about responding back to clients. So the industry average is it takes about 3 days to hear, once you reach out to an attorney, before they'll return your call, return your email, or do anything. Any correspondence, it takes about 3 days. And that frustrates everybody to no end. And I feel the same way. It's like when I built my house a few years ago, and I call the contractor up, and it'd take me 5 times trying to reach out to them. And I'd say, what's the status? And then it'd take another few days to get a status update. And it took you several days to even figure out what was going on. And so you're saying, man, I'm paying the attorney a lot of money. This is important to my business, and it takes me days to even get an answer. So when we did that, we said, we have a rule that we almost always will pick up the email or pick up the phone call as soon as a client calls. So we'll respond within a few minutes or take the call. And if we can, if we're in a meeting or in anything, we have a rule, we always respond within 24 hours. So you at least by the same day or that next morning get your answer. And that way everybody knows what's going on. They don't have to wait forever, and they can see it. So those are a few things when I said, okay, helping small businesses and startups, going to make the fees and understandable and easy to budget for. We're going to make sure that they know that they can sit down with us, strategize without having to pay for it. And then we're going to be responsive to make sure that they know what's going on at any given time, that they can talk with us and ask questions.
Biased, in fact, I don't think that biased is a bad thing, right? I think nobody goes into business or provides a service thinking that theirs is worse. So I expect you to be biased. That doesn't mean that your solution isn't better. As someone that has worked with different legal counsel, both here and in Europe, I've always found that there's different models. Some lawyers do things one way, some do it another. And I found your model to be pretty interesting, especially for someone that's still early on in the startup phase, especially with technology solutions and so on. I think it's nice to be like, okay, there's this protectable thing, and I can have a chat and I can figure out what's right and what's wrong. And then I have an idea of how much this is going to cost me. Nice.
Perfect.
Thank you so much. We'll keep in touch.
Well, so thanks for the chat and for having me on. It was great to talk, and let me know if I can do anything else to help with the study.